The case file that landed on Senior Assistant District Attorney Patricia Okonkwo's desk in March of 2017 was, by the standards of the Harris County District Attorney's Office, unremarkable. The defendant, Darnell Eugene Reeves, had been charged with aggravated assault with a deadly weapon following an altercation outside a convenience store on the 5800 block of Belfort Avenue in the South Park neighborhood of Houston, Texas. The victim, a 28-year-old man, had sustained a laceration requiring 11 stitches to the left forearm and a fractured orbital bone. He had provided a statement to responding officers within the hour. A witness had been identified. Physical evidence had been collected and logged. The arrest had been made within 72 hours. By the internal metrics the office used to assess a case's viability before committing it to the trial docket, this one scored well. Okonkwo had been with the office for 9 years. She had handled more than 300 cases across that span, the majority of them felonies, and she had developed the kind of professional fluency with the charging process that long institutional experience produces. She reviewed the offense report, the medical records documenting the victim's injuries, the inventory of physical evidence, which included a folding knife recovered from the vicinity of the altercation, and a cell phone belonging to the defendant that had been seized incident to arrest, and determined within the framework of Texas Penal Code Section 22.02 that the evidence supported a charge of aggravated assault. The statute required that the assault have been committed with a deadly weapon. A folding knife, under Texas case law, qualified. She noted the prior conviction on Reeves's record, a 2013 misdemeanor for simple assault, adjudicated in the same county, and filed the charge as a second-degree felony. Under Texas law, that classification carried a sentencing range of 2 to 20 years. The charging decision was reviewed by a supervising prosecutor before filing, as was standard practice in the office for felony cases. The supervisor reviewed the same materials Okonkwo had reviewed. He initialed the file. The charge was filed in the 202nd District Court of Harris County. The procedural architecture that followed was meticulous by design. Texas criminal procedure requires that a felony defendant be formally indicted by a grand jury before the case proceeds to trial, a constitutional protection intended to interpose a citizen body between the state's charging authority and the defendant's exposure to trial. The grand jury in the 232nd District Court heard the Reeves case in April 2017. Okonkwo presented the evidence, the offense report, the medical records, the knife, and the testimony of the investigating detective. The grand jury returned a true bill. The indictment was filed. Reeves was arraigned and entered a plea of not guilty. The grand jury proceeding is, by statute and by long practice, conducted without the presence of defense counsel. This is not an anomaly or an oversight. It is the design of the process, established in Texas law and consistent with practice in the majority of American jurisdictions. The grand jury's function is to assess whether probable cause exists to proceed, not to adjudicate guilt. The standard it applies is significantly lower than the beyond a reasonable doubt threshold that governs trial. The proceeding is ex parte by nature, meaning the state presents its evidence to the grand jury without adversarial challenge. Indictment rates in Harris County, as in most large urban jurisdictions, consistently exceeded 95% during this period. This figure reflects not the grand jury's deference to prosecutors, but in the institution's own framing, the care prosecutors exercise in bringing only cases that meet the probable cause threshold before the body. The system worked as it was designed to work. Reeves was appointed counsel from the Harris County Public Defender's Office, which had been established in 2011 following a state legislative mandate. His attorney, a staff public defender with 7 years of felony experience, filed a motion for discovery within 2 weeks of arraignment. The prosecution complied with its disclosure obligations under Texas Code of Criminal Procedure Article 39.14, the Michael Morton Act, passed in 2013 following a high-profile wrongful conviction case and widely regarded as one of the more comprehensive discovery statutes in the country. The prosecution provided the defense with the offense report, the medical records, the forensic analysis of the knife, the cell phone data, and the witness statement. The disclosure was timely. The materials were complete as required by the statute. Defense counsel reviewed the materials and identified what she believed was the most viable avenue for challenge: the eyewitness identification. The witness, a man who had been standing outside the convenience store when the altercation occurred, had identified Reeves from a photo array administered by a Houston Police Department detective 2 days after the incident. The array had been conducted using the department's standard sequential blind administration protocol, a procedure designed specifically to reduce the risk of suggestive identification by ensuring that the administrator did not know which photograph depicted the suspect. Defense counsel filed a motion to suppress the identification, arguing that the witness's opportunity to observe had been limited by lighting conditions and the duration of the altercation. The motion was argued before the court and denied. The ruling cited the totality of the circumstances standard established in Neal v. Biggers and applied consistently by Texas appellate courts. The identification had been obtained through a proper procedure. The legal standard had been met. The trial lasted 4 days. Jury selection had proceeded under the Batson framework, with both sides exercising peremptory challenges and the court adjudicating one challenge raised by the defense. The seated jury included 3 black members among its 12. The court's voir dire had addressed the presumption of innocence, the burden of proof, and the requirement that jurors set aside any preconceptions about the defendant or the charges. The jurors had affirmed their ability to do so. Okonkwo's case-in-chief was organized with the clarity that long trial experience produces. The victim testified first, describing the altercation in detail and identifying Reeves in open court. The medical records were introduced through the treating physician, who explained the nature of the injuries and their consistency with a knife wound. The forensic analyst testified regarding the knife, its mechanism, its blade length, and the conclusions she could draw from its recovery in the vicinity of the altercation. The eyewitness testified and identified Reeves. The detective testified to the investigation, the arrest, and the chain of custody of the physical evidence. Each witness was cross-examined by defense counsel. Each cross-examination was complete and professional. The defense presented an alibi. Reeves testified in his own behalf, stating that he had left the area before the altercation escalated and that the knife recovered by police was not his. His sister testified that she had spoken with him by phone at approximately the time of the altercation, though she acknowledged she could not verify his physical location from that conversation. Okonkwo's cross-examination of Reeves was methodical. She walked him through the timeline established by the other witnesses and noted the points of inconsistency between his account and theirs. She did not raise her voice. She did not editorialize. She asked questions and let the record speak. The jury deliberated for 5 hours and 40 minutes before returning a verdict of guilty. The judge sentenced Reeves to 8 years in the Texas Department of Criminal Justice. The sentence was within the statutory range. The judgment was entered. The appeals that followed produced no relief. The 14th Court of Appeals in Houston reviewed the record and affirmed the conviction in an opinion that addressed each assigned error and found none to be reversible. The Texas Court of Criminal Appeals declined review. the conviction became final. No one who participated in the prosecution of Darnell Reeves believed they had done anything other than their job. The evidence had been gathered, processed, and presented according to the rules that govern each step. The procedures designed to protect defendants from arbitrary state action had been applied. The jury had heard the evidence and reached a conclusion. The appeals courts had reviewed the record and found it legally sufficient. The outcome was, by every measure the system possesses, correct. The process had worked. The institution had performed its function. Confidence in the result was not unreasonable. It was, in fact, the logical response to a process that had followed its own rules at every turn. What those rules were designed to find and what they were designed to miss was a question no one in the courtroom had been asked to consider. The case against Darnell Eugene Reeves did not acquire its shape at trial. It acquired its shape in the weeks between the arrest and the indictment, during a series of decisions that were made inside the Harris County District Attorney's Office by professionals operating within the full authority of their institutional roles. Each decision was defensible, each was consistent with established practice, and each one narrowed, by increments too small to be individually challenged, the range of facts the jury would ultimately be permitted to consider. The first and most consequential of these decisions was the charge itself. Texas Penal Code Section 2202 defines aggravated assault as assault committed with a deadly weapon or causing serious bodily injury. The victim in the Reeves case had sustained a laceration requiring 11 stitches and a fractured orbital bone. The question of whether those injuries constituted serious bodily injury under Section 107A 46 of the Penal Code, defined as injury that creates a substantial risk of death, causes permanent disfigurement, or results in protracted loss or impairment of a bodily member or organ, was a legal judgment that Okonkwo was required to make at the charging stage. She made it in favor of the more serious charge. The orbital fracture, she determined, created a credible argument for protracted impairment. The laceration, combined with the knife, supported the deadly weapon theory independently. Either theory, standing alone, could support the aggravated assault charge. Together, they produced a case that was, from the state's perspective, doubly secured. What the charging decision also produced was a sentencing exposure of 2 to 20 years. This figure is not merely a legal abstraction. It is the architecture of the plea negotiation that follows every felony charge in the American system. The higher the sentencing ceiling, the greater the pressure on a defendant to accept a plea offer that resolves the case at a lower point on the range. Okonkwo's initial plea offer to Reeves was 5 years, deferred adjudication. Under Texas law, successful completion of deferred adjudication probation does not result in a final conviction, a significant benefit for a defendant concerned about the collateral consequences of a felony record. Reeves declined. He maintained his innocence. The offer was withdrawn when the case was set for trial, and the state proceeded on the full charge. The decision to charge at the aggravated level rather than the standard assault level, a charge that would have carried a maximum of 1 year in county jail, was a professional judgment made by one prosecutor, reviewed by one supervisor, and never subjected to any external scrutiny. It was also the decision that determined everything that followed: the court the case was filed in, the sentencing range the jury would be instructed on, and the frame within which every subsequent decision about evidence and witnesses would be made. Charging is the most powerful act in the criminal process. It is also the least visible. The knife recovered near the altercation was introduced at trial as State's Exhibit 3. The forensic analyst testified that it was a folding knife with a 3.5-inch blade, legally purchased and commonly available. she testified that it had been recovered approximately 12 feet from the location where the victim reported the assault occurred. She testified that no fingerprints had been recovered from the handle, a result she attributed to the textured grip surface, which is consistent with poor latent print retention. What the analyst did not testify to, because she was not asked, was the significance of the recovery location. 12 feet from the assault site, in an area that multiple people had moved through between the altercation and the officer's arrival, was a recovery that established proximity but not possession. The forensic report, which had been disclosed to the defense under the Michael Morton Act, included a site diagram that showed the knife's position relative to the victim's reported location, the defendant's reported location at the time of arrest, and the positions of two bystanders who had been present during the altercation. The diagram showed that the knife's recovery location was equidistant, within approximately 2 feet, from where Reeves had been standing and from where one of the bystanders, a man who had not been charged and whose name appeared in the offence report as a witness, had been positioned. Defence counsel had the diagram. She had raised the proximity issue during her cross-examination of the forensic analyst, but without a competing expert to contextualize the significance of the recovery location, the cross-examination produced limited traction with the jury. Retaining a forensic expert required funds that the Public Defender's Office had requested through its expert witness authorization process. The request had been approved for a reduced amount, sufficient to consult but not to retain for trial testimony. The consultation had confirmed that the recovery location was ambiguous. The testimony that would have communicated that ambiguity to the jury was not available. Okonkwo knew the diagram existed. She had reviewed it as part of her trial preparation. She had decided, as a matter of professional judgment, consistent with her obligation to present the strongest case the evidence supported, that the knife's proximity to Reeves, combined with the victim's testimony that Reeves had produced a knife during the altercation, was sufficient to establish the deadly weapon element. The ambiguity in the recovery location was the defense's problem to exploit, not the prosecution's problem to amplify. This is a legally accurate description of the adversarial system's allocation of responsibilities. It is also a description of how relevant uncertainty disappears from a trial record. The witness decisions shaped the case in ways that were similarly invisible in their operation. 4 individuals had provided statements to police in the hours following the altercation. The victim had given a detailed account. The eyewitness, the man outside the convenience store, had given an account that corroborated the victim's on the central points. A woman who had been inside the store and had come outside when she heard shouting had given a statement describing the altercation in general terms, but had told the detective that she had not seen clearly who had struck whom first. A second man, identified in the offence report only by first name and a physical description, had been interviewed briefly at the scene and had told officers that the altercation had appeared to begin with a shove from the victim's direction before escalating. The prosecution called the victim and the eyewitness. The woman, who had not seen clearly, was not called. The second man, whose account suggested a different sequence of initiation, was never definitively identified by investigators after the initial scene interview. His name did not appear in the discovery materials provided to the defense. The offense report noted his presence and his brief statement. It noted that follow-up contact had not been established. There was no legal requirement that investigators exhaust every effort to locate a witness whose account complicated the prosecution's theory. The report was disclosed. The lead, such as it was in the record. Defense counsel noted the reference in the offense report and made an effort to identify the individual through the physical description provided. The effort was unsuccessful within the time available before trial. This is documented in the public defender's file, reviewed years later by a legal researcher. The notation in the file reads, "Unidentified witness, no follow-up possible, trial date set." 4 words that mark the boundary between what the jury knew and what the record contained. Taken individually, none of these decisions constitutes a deviation from professional norms. The charge was legally supported. The evidence was introduced through proper procedure. The witnesses who testified were qualified, and their testimony was accurate so far as it went. The undisclosed witness had not been deliberately concealed. He had simply not been found, and the obligation to find him rested under the adversarial structure, at least as much with the defense as with the prosecution. Every choice Okonkwo made was a choice that experienced prosecutors make routinely in cases across the country every day that courts are in session. This is precisely what makes the pattern difficult to address. The problem is not that unusual decisions were made. The problem is that entirely usual decisions, made in sequence by a professional operating within her full authority, produced a record that pointed in one direction only. The jury that convicted Darnell Reeves saw a coherent, well-constructed case. They did not see the diagram, the unidentified witness, or the ambiguity in the knife's recovery location. They were not supposed to. The process had determined before they were seated what they would be allowed to see. The verdict they returned felt, from inside the courtroom, like a discovery. From a wider vantage point, it looks more like a destination that had been selected before the journey began. Harris County is the 3rd most populous county in the United States. Its criminal justice system processes tens of thousands of felony cases each year, moving them through a machinery of courts, prosecutors, public defenders, and correctional facilities that operates by institutional necessity at industrial scale. At that scale, individual cases become data points, outcomes become statistics. And the metrics by which the institution measures its own performance become, over time, the values the institution actually holds, regardless of what its mission statements say. The Harris County District Attorney's Office does not publish conviction rates as a formal performance benchmark. Neither do most large American prosecutors' offices. The reasons given for this are consistent across jurisdictions. Tracking convictions creates perverse incentives, encourages overcharging, and conflicts with the prosecutor's ethical obligation, articulated in the ABA model rules and in the Texas disciplinary rules of professional conduct, to seek justice rather than merely to win. These concerns are genuine, and the people who articulate them are, in most cases, sincere. The gap between that articulation and operational reality is not a product of bad faith. It is a product of how institutions actually function when formal policy and informal culture diverge. Within the Harris County office during the period relevant to the Reeves case, the informal culture around trial performance was well established. Attorneys who tried cases and won them advanced. Attorneys who tried cases and lost them were counseled, reassigned, or managed toward different roles. This is not a secret or a scandal. It is the natural operation of any competitive institutional environment in which performance is visible and advancement is limited. Trial wins are visible. The quality of judgment that produces them is not. An attorney who declines to charge a weak case exercises better professional judgment than one who charges it and loses. But the institution registers the second attorney as having a loss and the first as having done nothing at all. Caution is invisible. Aggression, when it succeeds, is rewarded. A 2018 internal review of the Harris County office, obtained through a public records request filed by a legal reform organization and subsequently reported in the Houston Chronicle, found that assistant prosecutors in the felony trial division were formally evaluated on criteria including courtroom demeanor, legal knowledge, and case management. It also found through interviews with current and former staff conducted as part of the review that the informal markers of advancement included trial record, supervisor perception of aggressiveness in charging, and reputation among colleagues as someone who could take a case to verdict. The review recommended the adoption of broader performance metrics. The recommendation was noted. Implementation was described in subsequent budget documents as ongoing. The structural imbalance between the Harris County District Attorney's Office and the Harris County Public Defender's Office is not a recent development, and it is not unique to Harris County. It is a feature of the American criminal justice architecture that has been documented, litigated, and lamented for decades without being fundamentally altered. At the time of the Reeves trial, the District Attorney's Office employed approximately 280 assistant prosecutors. The Public Defender's Office, established only in 2011 and still in the process of scaling its operations, employed 61 staff attorneys. The caseload disparity was significant. Public defenders in the felony division carried an average of 68 active cases, a figure that, while within the range of formally recommended maximums, left limited room for the kind of intensive investigation that complex cases require. The public defender assigned to Reeves was experienced and capable. She was also, at the time of trial, managing 54 other open files. Resource asymmetry compounds the caseload problem in ways that accumulate invisibly across thousands of cases. The District Attorney's Office had direct relationships with the Houston Police Department's forensic laboratory, established protocols for requesting investigative follow-up, and decades of accumulated institutional knowledge about which experts produced the most credible testimony on which categories of evidence. The Public Defender's Office had a developing network of experts and an authorization process for expert funding that required approval at the supervisory level. The approval process was not obstructive by design. It was a fiscal control mechanism in an office operating with a budget that, per capita, was a fraction of the prosecution's. The practical effect, in any individual case, was delay and uncertainty at precisely the moments when speed and certainty were most valuable. The Supreme Court's framework for assessing the adequacy of legal representation, established in Strickland v. Washington in 1984 and unchanged in its essential structure since, requires a defendant claiming ineffective assistance to demonstrate both deficient performance and resulting prejudice. The performance standard asks whether counsel's conduct fell below an objective standard of reasonableness. The prejudice standard asks whether, absent the deficient performance, the outcome would probably have been different. Both prongs are demanding. Courts applying Strickland have upheld convictions in cases involving attorneys who failed to investigate available witnesses, missed filing deadlines, and conducted cursory cross-examinations. The standard does not ask whether the defendant received the quality of representation that a well-resourced private attorney would have provided. It asks whether the representation was so deficient as to be constitutionally intolerable. These are substantially different questions, and the gap between them is where the structural imbalance lives. The academic literature on bias in prosecutorial decision-making has grown substantially over the past 2 decades, and its findings have become difficult to dismiss even as they remain contested in their policy implications. The consistent finding across studies examining charging decisions, plea offers, and sentencing recommendations is that race functions as an independent variable, one that predicts outcomes after controlling for offense severity, criminal history, and other legally relevant factors. The effect is not large in any individual case. It is not easily traceable to any individual decision. It is, however, consistent and cumulative across the thousands of decisions that constitute a jurisdiction's aggregate output. A 2017 study published in the Journal of Empirical Legal Studies examined felony charging decisions in a large urban Texas jurisdiction. Not identified by name in the study, though the data parameters were consistent with Harris County, and found that black defendants facing assault charges were charged at the felony rather than the misdemeanor level at a rate approximately 1.3 times higher than white defendants with comparable offense characteristics and criminal histories. The study's authors were careful to note what this finding does and does not mean. It does not mean that any individual prosecutor made a charging decision based on the defendant's race. It means that, across thousands of decisions made by dozens of prosecutors over multiple years, the aggregate pattern is not explained by the legally relevant variables. Something else is doing work in the decision-making process. The study's framing for that something else is unobserved factors, a term of art that encompasses implicit bias, cultural assumptions, neighborhood-level generalizations, and the accumulated weight of professional experience in a system that has historically produced racially disparate outcomes. This is what institutional bias looks like when it is operating normally. It does not look like a decision. It looks like a pattern. And patterns are visible only at a scale that no individual decision-maker ever occupies. The prosecutor making a charging decision sees one case, one defendant, one set of facts. She does not see the 847 other charging decisions made by her colleagues that year, or the aggregate effect of the discretionary choices distributed across those cases, or the demographic profile of the outcomes those choices produced. The pattern exists at the institutional level. Accountability, such as it is, exists at the individual level. The two registers never quite meet. The architecture of plea bargaining intensifies this dynamic in ways that are rarely examined directly. Approximately 95% of felony convictions in Harris County, as in most large American jurisdictions, are resolved through guilty pleas rather than trials. This means that the charging decision made by one prosecutor, reviewed by one supervisor, and insulated from external scrutiny by the doctrine of prosecutorial discretion effectively determines the outcome of the case for the vast majority of defendants. The trial, with its procedural protections and its constitutional guarantees, is the exception. The charging decision, made in a conference room without a jury or a judge or a public record, is the rule. And it is in that conference room, in the aggregate of thousands of such rooms across thousands of such decisions, that the system's biases are most consequentially expressed. The Reeves case did not require a conspiracy. It did not require that anyone act in bad faith, violate a rule, or make a decision they understood to be wrong. It required only that a set of institutional incentives, rewarding conviction, penalizing caution, under-resourcing defense, insulating discretion from review, operate as designed across a system that processes human lives at industrial scale. Patricia Okonkwo charged the case she believed the evidence supported. She tried it competently and won. She moved to the next file. Darnell Reeves was processed through a system that had been calibrated over decades of accumulated policy and practice to produce exactly the kind of outcome his case produced. No individual made that happen. The institution did, and the institution, by every measure it applies to itself, performed correctly. That is the part that resists easy resolution. Injustice, in its most durable forms, does not require intent. It requires only design, and a system disciplined enough to follow it. Darnell Eugene Reeves arrived at the Darrington unit of the Texas Department of Criminal Justice in the fall of 2017. He was 34 years old. He had been employed as a commercial electrician's apprentice for the previous 2 years, working toward a journeyman's license through a union apprenticeship program that required the completion of 4 years of combined classroom instruction and fieldwork. He had completed 31 months of that program at the time of his arrest. The conviction terminated his enrollment. The apprenticeship program's bylaws did not permit the continuation of membership following a felony conviction. There was no appeals process within the program. The rule was administrative, not punitive in intent, and it applied uniformly. It ended his enrollment with the same procedural neutrality that had characterized every other stage of the process that produced his conviction. His mother, who had attended every day of the trial, took the bus from South Park to the Darrington unit in Brazoria County on the first available visiting day following his intake processing. The unit is located approximately 50 miles south of Houston. The bus journey, requiring 2 transfers, took 3 hours and 40 minutes each way. She made that journey 23 times over the course of the first 2 years. This is not in any legal record. It is the kind of fact that exists entirely outside the system's accounting. A cost denominated in hours and bus fares, and the particular exhaustion of a woman in her late 60s traveling to a correctional facility on a weekday because her son was inside it. Reeves's daughter, who was 9 years old at the time of sentencing, was in his mother's care during his incarceration. The child's school records from that period, reviewed by a legal researcher examining collateral consequences documentation in Harris County cases, note a pattern consistent with what developmental psychologists term adverse childhood experiences. Declining academic performance in the year following the parent's incarceration, increased absences, and a referral to the school counselor in the spring of 2018. The referral form does not mention her father's incarceration. It describes the presenting concern as difficulty concentrating and peer conflict. The connection between those symptoms and the event that preceded them is not established in any official document. It exists only in the space between 2 facts that the system records separately and never brings into contact with each other. The legal effort to revisit the Reeves conviction began not with new evidence of innocence, but with a pattern. In 2020, a clinical professor at the University of Houston Law Center, who had been studying charging disparities in Harris County felony cases, identified the Reeves file as part of a cohort of assault convictions in which the elevation from standard to aggravated charge appeared, on the face of the record, to involve closer legal questions than the case files typically reflected. The cohort was not defined by the race of the defendants. It was defined by the ambiguity of the deadly weapon determination and the absence of documented reasoning in the charging file. The demographic composition of the cohort, once identified, was consistent with the patterns the broader literature had described. Black and Hispanic defendants were overrepresented relative to their proportion of assault arrests in the county during the relevant period. The clinic filed a petition for writ of habeas corpus in the trial court in March 2021, arguing that the conviction rested on constitutionally insufficient evidence, specifically that the state had failed to prove beyond a reasonable doubt that the knife recovered from the scene was the weapon used in the assault, given the ambiguity of its recovery location and the absence of forensic evidence linking it to Reeves. The argument was not new. It had been raised in a different form on direct appeal. The 14th Court of Appeals had addressed it and rejected it. The habeas petition reframed the argument in light of a 2019 Texas Court of Criminal Appeals decision that had clarified the evidentiary standard for deadly weapon findings in cases involving recovered but unidentified weapons. The state's response to the habeas petition was filed by the Harris County District Attorney's Conviction Integrity Unit, a division established in 2016 specifically to review claims of wrongful conviction and widely cited as a model for prosecutorial accountability. The unit's response ran to 31 pages. It was carefully argued and legally thorough. Its central conclusion was that the evidence at trial, viewed in the light most favorable to the verdict, was sufficient to support the deadly weapon finding under the applicable standard, and that the 2019 Court of Criminal Appeals decision did not represent a change in law material enough to constitute a basis for habeas relief. The unit did not address the charging disparity data. It was not required to. The habeas framework does not recognize aggregate statistical patterns as a basis for individual relief. The law reviews convictions one at a time against the record of the individual case through standards that were designed to correct identifiable legal errors rather than to interrogate the systemic conditions that produced them. The habeas petition was denied. The denial was appealed. The Court of Criminal Appeals refused discretionary review. The doctrine of prosecutorial immunity, which the Supreme Court affirmed in Imbler v. Pachtman in 1976 and has consistently reaffirmed since, operates in the Reeves case as it operated in the legal landscape described in the earlier account from Cuyahoga County, as a structural barrier between the exercise of prosecutorial discretion and any form of post hoc civil accountability. Okonkwo made the charging decision. She made the evidence-framing decisions. She made the witness selection decisions. All of these decisions were made in her capacity as an advocate for the state, and all of them are therefore absolutely immune from civil liability, regardless of their consequences and regardless of whether, examined in retrospect, they reflected the kind of accurate professional judgment the system assumes they did. This immunity is not an accident of legal history. It is a considered institutional choice made by the judiciary over decades of common law development and constitutional interpretation to preserve the independence of prosecutorial decision-making from the distortions that civil liability would introduce. The rationale is functional and, on its own terms, coherent. A prosecutor who feared personal liability for every charging decision that a jury later rejected would be paralyzed. The system requires that prosecutors make consequential decisions under conditions of uncertainty, and it protects those decisions from second-guessing in order to make that requirement viable. The practical effect of this protection, in the aggregate, is that the decisions most consequential to the outcomes the system produces are the decisions least subject to external accountability. Charging, plea structuring, evidence framing, witness selection, the choices that determine what a jury sees before it sees anything, are made inside the institution, ratified by the institution, and defended by the institution against review. The conviction that emerges from this process carries the institution's full authority. The process that produced it is largely unreachable. Darnell Reeves was released from the Darrington unit in January 2023, having served 5 years and 3 months of an 8-year sentence. His electrician's apprenticeship had been terminated. His union membership was gone. The journeyman's license he had been 31 months into earning when he was arrested remained unattained. Texas law permits some individuals with felony convictions to obtain occupational licenses through a process of individual review, but the review is discretionary, the criteria are vague, and the outcomes are inconsistent. His application, filed in the spring of 2023, was pending at the time the case materials used in this account were last reviewed. His daughter was 15. His mother's health had declined during his incarceration in ways that his absence had complicated, and that his return could not reverse. He was not exonerated. His conviction remained on the record, accessible to any employer, landlord, or licensing authority that conducted a background check. He was, by the law's accounting, a man who had been convicted of aggravated assault with a deadly weapon, had served his sentence, and was now free. The title of this account describes a conviction that followed the rules. That description was accurate when it was first applied, and it remains accurate now. The rules were followed at every stage. The charging decision was within the prosecutor's authority. The evidence was presented lawfully, the jury was properly instructed, the appeals were properly adjudicated, the institution reviewed itself and found itself correct. What the rules were not designed to detect, what they have never been designed to detect, is whether the aggregate of individually lawful decisions, made within a system calibrated by incentives that reward conviction and insulated by doctrines that shield discretion, produces outcomes that correspond to truth. The system does not ask that question. It is not structured to ask that question. It is structured to produce outcomes, to defend them, and to treat the absence of reversible legal error as the equivalent of justice. Whether those two things are the same is a question the system leaves unanswered. It has always left it unanswered. The case of Darnell Eugene Reeves joined a long record of cases in which the rules were followed, the process was completed, and something that cannot be named within the law's own vocabulary was nonetheless lost. The system recorded his case as closed. It was the only kind of accounting it knew how to do.